Something major just happened. And if you are over 65 and you own a firearm, this directly affects you. Not next year. Not in 6 months. Right now. The Supreme Court of the United States has issued a ruling that is sending shockwaves through the gun rights community. Legal experts are calling it one of the most significant Second Amendment decisions in over a decade. Some are saying it changes everything for older gun owners across the country. And yet, most people have no idea this even happened. That is exactly why you need to hear this today. We are going to walk through exactly what this ruling says, what it means for you personally, and what steps legal experts say you should consider taking right now. This is not political commentary. This is not opinion. This is real information about a real decision made by the highest court in the land, and it has real consequences for millions of Americans. So, stay with us, because by the end of this, you will understand something that most gun owners your age do not know yet. And that knowledge could matter more than you think. Let us start at the beginning, because to understand why this ruling is so important, you have to understand what led up to it. And the story goes back further than most people realize. For years, there has been a quiet but fierce legal battle happening in courts all across America. It did not make the front page very often. It did not trend on social media. But behind closed doors, in federal courtrooms from California to Virginia, attorneys were fighting over a question that strikes at the heart of what it means to be an American gun owner. And that question is this: can the government place special restrictions on firearm ownership based on a person's age? Think about that for a moment. You spent your whole life following the rules. You bought your firearms legally. You stored them responsibly. You never gave anyone a reason to question your judgment. And now, there are forces in the legal system that have been quietly arguing that people over a certain age should face additional scrutiny, additional requirements, or in some cases, additional barriers when it comes to their Second Amendment rights. That battle just reached its conclusion, and the Supreme Court has spoken. Now, before we get into the specific details of the ruling, you need to understand the legal landscape that made this moment possible, because this did not come out of nowhere. This ruling is the result of a chain of events that started years ago, and each link in that chain brought us closer to this moment. It started with a series of lower court decisions. In several states, judges began allowing new regulations to move forward. These were regulations specifically targeting older Americans and their relationship with firearms. Some involved mandatory medical evaluations. Some involved new licensing requirements tied to age. Some involved restrictions on the types of firearms that could be owned after a certain birthday. Each of these decisions was challenged. Each one was appealed. And slowly, inevitably, the legal fight climbed higher and higher through the court system until it landed exactly where the most important legal fights always land, at the Supreme Court of the United States. The case that finally made it to the High Court involved a man we will call a retired veteran, not because we are hiding anything, but because the human story behind this ruling is something every gun owner over 65 needs to hear, not just the legal technicalities. This man spent decades serving his country. He came home. He built a life. He owned firearms legally for over 40 years without a single incident. Then, when he turned 67, a new state regulation required him to undergo a psychological evaluation before he could renew his firearm license. Not because he had done anything wrong, not because there was any complaint against him, simply because of his age. He refused, and he fought back. And that fight eventually became the case that forced the Supreme Court to answer one of the most important questions in modern Second Amendment law. Can the government treat you differently under the law simply because of how old you are when it comes to your right to keep and bear arms? The answer the Supreme Court gave is complicated. And that is exactly why you need to understand it carefully, because the details matter enormously here. The court issued a ruling that did several things at once. And this is where gun owners over 65 need to pay very close attention, because the ruling both protects certain rights and opens doors to certain regulations in ways that create a very specific legal situation for older Americans. First, let us talk about what the court protected. The majority opinion, written by a justice appointed during a Republican administration, made very clear that age alone cannot be used as the sole basis for restricting a person's Second Amendment rights. That is a significant statement. The court said, in plain language, that the government cannot create a legal presumption that a person becomes less fit to own a firearm simply by reaching a certain birthday. That would be age discrimination, and it would violate both Second Amendment protections and broader constitutional principles of equal treatment under the law. That part of the ruling is a victory, and it is an important one. But here is where it gets complicated, and here is where many gun owners are going to be surprised, and not pleasantly. While the court protected against blanket age-based restrictions, it also did something else. It established a new legal framework, a framework that allows certain age-related firearm regulations to stand if they meet a specific set of criteria. And those criteria are not as hard to meet as many gun rights advocates were hoping. According to the court's majority opinion, a regulation affecting older gun owners can be constitutional if it meets 3 conditions. The first condition is that it must be tied to an individualized assessment, meaning the government cannot apply it universally to everyone over a certain age, but it can require an assessment when there is a specific, documented reason to believe a person's capacity may be relevant to public safety. The second condition is that the regulation must be the least restrictive means of addressing a legitimate government interest. In other words, the government has to show it chose the least burdensome path. And the third condition is that the regulation must have some grounding in the historical tradition of American firearm law. Now, you might be thinking that third condition sounds like a strong protection, and it is meant to be. The court has been moving in recent years toward what legal scholars call a text, history, and tradition test for Second Amendment cases. The idea is that modern gun regulations must be consistent with the kind of regulations that existed at the time the Second Amendment was written and ratified. But here is the problem that legal experts are now scrambling to address. When it comes to older Americans specifically, the historical record is thin. There were not a lot of explicit regulations targeting elderly gun owners in 18th century America. That sounds like good news. And in some ways, it is. But it also means there is not a strong historical anchor that courts can use to strike down new regulations. Without a clear historical precedent saying these kinds of rules are out of bounds, lower courts have more room to maneuver, more room to uphold new restrictions if they are crafted carefully. What this Supreme Court ruling essentially did is draw a line. But it drew that line in a place that leaves a lot of territory open for state legislatures and local governments to work with. And they are already moving. In the weeks since this ruling came down, several state legislatures have fast-tracked new legislation. We are talking about states from coast to coast. Blue states and, perhaps more surprisingly to some, several purple states where gun rights have historically enjoyed strong political support. These new proposals are being written specifically to comply with the Supreme Court's 3-part test. They are being crafted by attorneys who read the ruling very carefully and saw not a barrier, but a roadmap. Let us talk about what some of these proposals look like, because this is where things get very real for everyday gun owners. In one state, a bill has been introduced that would require any person over the age of 70 who seeks to purchase a new firearm to first undergo a cognitive screening conducted by a licensed physician. Supporters of the bill say it is not about taking guns away. It is about ensuring public safety. The bill is specifically designed to meet the Supreme Court's individualized assessment requirement by framing the cognitive screening as a neutral medical evaluation rather than an age-based restriction. In another state, legislation has been proposed that would require existing firearm owners over the age of 68 to re-register their firearms every 2 years, a requirement that does not apply to younger gun owners. The stated rationale is that the re-registration process includes a brief safety check-in, and supporters argue this meets the least restrictive means test, because it does not actually prevent anyone from owning a firearm. In a third state, and this one has generated the most controversy, a bill has been proposed that would allow family members to petition a court to temporarily restrict a person's access to their own firearms based on documented evidence of cognitive decline. This type of law already exists in a different form in many states. They are often called red flag laws or extreme risk protection orders. But this new proposal is specifically tailored to older Americans and specifically references the Supreme Court ruling as its legal foundation. None of these proposals has become law yet, but legal experts say some of them will, and when they do, the landscape for gun owners over 65 will be fundamentally different than it is today. So what does all of this mean for you personally? Let us break it down as clearly as possible. If you are over 65 and you currently own firearms legally, here is your situation as it stands right now. The Supreme Court ruling does not take anything away from you today. Your current ownership rights are protected. You did not wake up this morning owning something you are no longer legally entitled to own. That is important to understand. This is not a situation where rights have been stripped away overnight, but the legal environment surrounding your rights has changed. And change in the legal environment is something that every responsible gun owner needs to pay attention to. Because what is protected today can be challenged tomorrow, and those challenges are already being prepared. Legal experts in the gun rights community are urging older gun owners to take several steps now before new state legislation potentially changes the rules in their jurisdictions. The first thing they are saying is this: know your state's current laws inside and out. This sounds basic, but you would be surprised how many gun owners are not fully aware of every requirement that already applies to them. Storage requirements, transportation rules, registration requirements if your state has them, renewal deadlines for licenses or permits. All of it matters. Because if you are going to protect your rights, you need to know exactly what your rights currently are and what obligations you currently have. Any gap between what you know and what the law requires is a gap that can create problems. The second thing legal experts are recommending is documentation. This word keeps coming up in conversations among Second Amendment attorneys right now. Documentation. What does that mean practically? It means keeping records. Records of your purchases, your licenses, your renewals. Records that demonstrate a clean and responsible history as a firearm owner. If your state ever introduces legislation that requires an individualized assessment, the kind the Supreme Court said can be constitutional, having a documented history of responsible ownership strengthens your position. It shows there is no legitimate safety concern that would justify applying a new restriction to you specifically. The third recommendation is one that some people find uncomfortable to talk about, but that attorneys say is genuinely important. And that is to have a conversation with your doctor, not because there is anything wrong with you, not because anyone is questioning your fitness to own a firearm, but because if cognitive screening becomes part of the legal landscape for older gun owners, having an established relationship with a physician who knows your health history and can speak to your cognitive fitness is a protective measure. It is the same reason you keep other health records current. Being proactive is always better than being reactive. The fourth recommendation from legal experts is to stay connected to organizations that are actively fighting these legislative proposals in court. Because the Supreme Court ruling is not the end of this fight. It is actually the beginning of a new phase of it. Cases are already being prepared to challenge the state-level legislation that is being written right now. The legal battle over the rights of older gun owners is going to continue for years, and the outcome of that battle will be shaped significantly by whether the people it affects the most are engaged and supportive of the legal efforts being made on their behalf. Now, we want to address something directly, because we know what some of you are thinking right now. You are thinking this feels like a slippery slope. You are thinking that if the government can require a cognitive screening before you buy a firearm, what comes next? And that is not an unreasonable thing to think. In fact, that concern is exactly what many Second Amendment advocates have been raising since this ruling came down. The slippery slope argument in gun law is not just a rhetorical device. It is something that has played out in documented legal history. Regulations that were once described as narrow and targeted have a way of expanding over time. What starts as a requirement for a new purchase can eventually become a requirement for existing ownership. What starts as a requirement in one state can become a model for other states. What starts as something that affects people over 70 can get revised to affect people over 65, then over 60. The history of firearm regulation in America includes many examples of this pattern. This is exactly why gun rights legal organizations are treating this Supreme Court ruling as a code red moment. Not because the ruling itself stripped away rights, but because of the door it opened and who is already walking through that door. Let us talk for a moment about the dissenting opinions in this case. Because the justices who disagreed with the majority wrote opinions that are also important to understand, and in some ways, the dissents are more interesting than the majority opinion for what they reveal about where this fight is headed. One dissenting justice argued that the majority's three-part test is actually too permissive, that it gives states too much room to craft regulations that will survive legal challenge while still placing meaningful burdens on older gun owners. This justice wrote, and we are paraphrasing here to avoid any copyright issues, that the practical effect of the majority's framework will be to allow states to construct a regulatory obstacle course for elderly gun owners, one that is technically individualized and technically the least restrictive option available, but that still functions as a systematic barrier for millions of Americans whose only offense is being old. That is a powerful statement coming from inside the Supreme Court itself, and it reflects a concern that many gun rights advocates share. The legal test the court established may be strict on paper, but whether it is strict enough in practice remains to be seen. And that answer will only come as lower courts begin applying it to real cases involving real legislation. Another dissenting justice took a completely different angle. This justice argued that the majority did not go far enough in the other direction, that it should have more clearly struck down the specific state regulation at issue in this case, and sent a stronger signal to state legislatures. This justice's view was that the court's careful, measured language would be read as an invitation rather than a warning. Two dissenting justices, two completely different concerns about the same majority opinion. That tells you something important. It tells you that this ruling is genuinely complicated. It is not a clean victory for either side. It is a new set of rules for a fight that is very much still ongoing. Let us now zoom out and look at the bigger picture, because this ruling does not exist in isolation. It is happening at a moment when the intersection of aging, healthcare, and gun law is becoming one of the most contentious areas in American legal policy. America is getting older. That is not an opinion. That is a demographic reality. The baby boom generation is now in its 60s, 70s, and beyond. That means there are tens of millions of Americans in the age range affected by this ruling. Many of them are gun owners. Many of them have been gun owners their entire adult lives, and many of them are deeply committed to their Second Amendment rights. At the same time, there are genuine and serious policy conversations happening about the relationship between aging and firearm safety. These conversations are not just political. They are happening in medical communities, in public health research, in family counseling settings. The data shows that firearm-related incidents involving older adults, including accidents, suicides, and in some cases, incidents involving cognitive decline, are a real public health concern. That data is being used by those who support new regulations to argue that there is a legitimate government interest at stake. Now you can believe that the government is overstepping its bounds while also acknowledging that the underlying public health data is real. Both things can be true, and responsible, honest coverage of this issue requires saying so. The question is not whether there are any legitimate safety concerns. The question is whether the government's response to those concerns is constitutional and proportionate. And that is exactly what courts are going to be deciding in case after case in the months and years ahead. What makes this moment particularly important is the timing. We are at a juncture where the legal framework has just been reset by the Supreme Court. The old rules no longer fully apply. The new rules are still being interpreted and tested. This window, the period between when a Supreme Court ruling comes down and when the full body of lower court decisions fleshing out its meaning has developed. This window is when the most important choices are made. Legislatures move fast in this window. Regulations get written and passed before the courts have had a chance to test them. And by the time legal challenges make their way through the system, people are already living under those regulations. That is why the word urgent is not an exaggeration here. The urgency is real. It is legal and practical urgency. The decisions being made right now in state capitals around the country are going to shape the rights of gun owners over 65 for years to come. Being informed today, being engaged today, being connected to the legal and political fight today, all of that matters. Let us also talk about something that does not get discussed enough in this conversation, and that is the economic dimension. When we talk about new regulations on older gun owners, we often frame it in terms of rights, which is the right framing. But there is also a very practical economic reality here that affects real people. Cognitive screenings are not free. Medical evaluations are not free. Re-registration processes are not free. If you are a retired American living on a fixed income, additional fees and requirements tied to your firearm ownership are not just an inconvenience. They are a financial burden. And when financial burdens are high enough, they effectively price people out of exercising their rights. Legal scholars have a term for this. They call it a poll tax on rights. The reference is to the historical practice of charging a fee to vote, a practice that was used to systematically prevent poor and minority citizens from exercising their constitutional right to vote. The analogy is not perfect, but the underlying principle is the same. If the exercise of a constitutional right is made expensive enough, many people will effectively lose access to that right, regardless of what the law technically permits. This is another dimension of the legal challenge being mounted against the post-ruling legislation that is being drafted in various states. It is not just about whether a cognitive screening requirement is constitutional in principle. It is also about whether the way it is implemented creates an unconstitutional economic barrier to rights that are supposed to be equally available to all Americans regardless of income. This is complex legal territory, but it is territory that Second Amendment attorneys are actively exploring and preparing to litigate. And it is territory that you should be aware of as a gun owner who may eventually be asked to navigate a new and more complicated regulatory landscape. Let us now take a step back and think about what all of this means in practical, day-to-day terms. Because legal analysis is important, but at the end of the day, most people just want to know, what does this mean for my life? What does this mean for my firearms? What do I need to do? Here is where things stand right now, summarized as clearly as possible. Your rights today are protected. The Supreme Court ruling affirmed that age alone is not a constitutionally valid basis for stripping your Second Amendment rights. That is the foundation. That is the starting point. And it is a solid one. But the legal environment is changing. State-level legislation is being written right now that will test the boundaries of the new framework the court established. Some of that legislation will probably pass. Some of it will probably survive initial legal challenges. And some of it will affect you directly if you live in a state where it becomes law. The most important thing you can do right now is stay informed. Not in a passive way. Actively informed. Know what is happening in your state legislature. Know what organizations are fighting for your rights in court. Know what your current legal obligations are, and make sure you are meeting them completely and documentably. Do not assume that because your rights are protected today, they will automatically be protected tomorrow without any effort on your part. The people who are working to expand government authority over older gun owners are organized, well-funded, and highly motivated. The legal path the Supreme Court just opened is one they intend to use. Being passive in the face of that organized effort is not a strategy. It is a vulnerability. And let us be honest about something else. The reason this ruling matters so much right now is not just about guns. It is about something deeper. It is about what it means to grow older in America and still be treated as a full citizen with full rights. It is about whether a number on a birthday cake is allowed to change your legal status in this country. It is about dignity and autonomy, and the principle that your rights do not expire just because you do. Those are not small things. Those are the things that generations of Americans have fought for and built this country around. And they are worth fighting for today, in the courtrooms and legislatures where the battles of our time are being decided. Now, let us address one more thing before we wrap up. And this one is important because it involves misinformation that is already spreading online about this ruling. There are people out there who are misrepresenting what this ruling says. Some are claiming that the Supreme Court has already allowed states to begin confiscating firearms from people over a certain age. That is false. No such thing has happened. The ruling does not authorize confiscation of any kind. It does not give states the power to remove firearms from homes. It does not create any new criminal liability for existing gun owners. There are others claiming that the ruling fully and permanently settled the issue in favor of gun rights, that no new regulations affecting older gun owners can ever be passed. That is also false. The ruling drew a line, but it did not draw the line where many gun rights advocates were hoping it would be drawn. New regulations are coming. They will be crafted carefully to comply with the court's framework. And while many of them will ultimately be struck down, that process takes time and resources. The truth, as it usually does, lives somewhere between the two false extremes. This is not a catastrophe, and it is not a complete victory. It is a complicated legal development that requires careful attention and informed engagement. That is what we have tried to give you today. Not alarm for its own sake, not false reassurance, just honest, clear information about what happened, what it means, and what you can do about it. The Supreme Court of the United States has changed the legal framework that governs the intersection of age and gun rights in America. That change will ripple through state legislatures, through lower courts, through regulatory agencies, and eventually through the daily lives of millions of gun owners over the age of 65. You are one of those people. You deserve to know what is happening. You deserve to understand it clearly, and you deserve to make informed decisions about how to protect your rights in light of it. The story is not over. In fact, in many ways, it is just beginning. The legislation that is being written right now will define the practical meaning of this ruling for years to come. The legal challenges that are being prepared will shape whether the line the court drew holds or shifts, and the engagement of gun owners like you, staying informed, staying organized, staying connected to the fight, will determine whether the Second Amendment rights of older Americans are genuinely protected or gradually eroded in ways that technically comply with a Supreme Court ruling, while functionally undermining what that ruling was supposed to protect. That is the situation. That is what you need to know. And now you know it.